Hi. Hi, everyone.
Hello, ma'am.
Hi, everyone.
Hello.
Hi, Deepak. Hi, James.
Hi, Anu. Hi, James. Pramati, can you hear me properly?
Yes, I can.
Pramati, you had a look at my suggestion for the approach you could take.
Yes, ma'am. I've taken exactly that.
Okay.
So I'll just give a very brief introduction just for 2 minutes about the topic, and then I'll introduce all of you. And then, as you said, Deepak can start, then Professor James, and then you.
Okay. Call me by my first name. Anu is fine.
Okay.
Anuradha.
All
Yeah.
right. Okay.
Deepak, are you at home or office?
I'm at home. So Geneva has more or less reopened, but I continue to work from home. How about you, Anu?
At home. This is
Home.
Yeah.
James, are you in Kerala now? James, can you hear me?
Yeah, I'm also at home.
Are you in Kerala or Delhi?
In Delhi.
Okay.
I wanted to go to Kerala, but then I couldn't get on time.
James, your voice is very faint. Can you all hear him clearly?
I can't very well.
I'm actually using my mobile phone.
This is better. Just come closer when you talk, I think.
Yeah, maybe there was some distance between me and the phone.
Okay.
You might have to use a headphone then. At times it's difficult to hear you.
When the chat makes battery, then it is like computer don't have its phone. So I thought of
Can't hear James.
Pramati, let's start then.
Yeah.
Good evening and welcome to this session of the NUJS Online Lecture Series hosted by the NUJS Student Juridical Association of 2019-2020 in collaboration with the NUJS Society for International Trade and Competition Law. With us today, we have Dr. James Nedumpara, Ms. R.V. Anuradha, Mr. Deepak Raju, and Ms. Pramati Parwani. The discussion will be on the topic Current Crisis at the WTO. We will have a Q&A session at the end of the discussion. However, the viewers can also post their questions during the session as well. Our moderator for the session is Ms. Pramati Parwani. Pramati is a 2019 alumnus of NUJS and has obtained her LLM in International Economic Law from the Graduate Institute. Pramati is a winner of the 2015 edition of the ELSA Moot Court and a recipient of the Global Scholarship to attend the Summer Academy at the World Trade Institute in Rome. We would like to express our deep gratitude to the guests for being a part of this session. On that note, I'll hand over to Pramati to introduce our panelists and commence the session.
Thank you, Jacob. Welcome everyone to this panel discussion on the current crisis of the WTO. Now, before I introduce our esteemed panelists, I'll give a very quick introduction to the topic. When we talk about the current crisis at the WTO, of course, the main thing that we talk about is the WTO appellate body crisis. So, in a nutshell, for quite a few years now, the United States had been blocking the appointment of judges or members to the appellate body. The 7-member body requires at least 3 members to be able to sit on a bench and decide on appeals. However, on December 10th, 2019, after the retirement of 2 judges from the appellate body, only 1 member now remains at the appellate body. This means that effectively the appellate body has stopped functioning. It cannot hear any more new appeals. It delivered its final judgment in the plain packaging dispute recently last month. And as of now, it is not able to hear any more disputes. The problem is that panel proceedings still continue, which means that technically the right to appeal from the panel proceedings or the panel report still exists and is available to the parties. However, without the appellate body, this right is now quite contentious, and there is quite a lot of problems arising from this. Over the last few months, an interim solution has been found in the form of the MPIA. The full form of MPIA is the Multi-Party Interim Appeal Arbitration Arrangement. This is essentially under Article 25 of the Dispute Settlement Understanding, which provides for arbitration as an option to resolve disputes between the parties. This MPIA is a plurilateral arrangement between a few countries. The most notable members are the European Union and China. There are, of course, several abstentions from this. Most notably, the USA has, of course, not signed on to the MPIA. India as well is not a party to the MPIA right now. Now, in addition to the appellate body crisis, there are several other factors at play as well here. The causes behind these factors and their impact varies depending on who exactly you ask. But briefly, these factors are as follows. First of all, there has been the multilateral negotiations have not been able to reach any binding treaties in the past few years at the WTO. The Doha development round has been criticized as being a complete failure. In addition, there's rising unilateralism by the United States, which is evident from the US-China trade war. And finally, in May, the Director General of the WTO, Roberto Azevedo, also resigned. This was 1 year before his term was actually supposed to end. He'll exit in August, and right now the search for a new Director General is ongoing. But we will be looking at, in this session, at the effect of these different factors on the crisis at the WTO. So now moving on to our panelists for today. First, we have Mr. Deepak Raju, who is an alumnus from NUJS. He then obtained his LLM from Cambridge. He is now a senior associate at Sidley Austin, which is a premier law firm dealing with trade law in Geneva. Sidley Austin was one of the first firms to talk about the idea of Article 25 arbitration as a solution to the appellate body crisis, as a temporary alternative to the appellate mechanism. So Mr. Deepak Raju will be talking about the appellate body crisis and the origins of the MPIA. We then have Professor Dr. James Nedumpara. He is the professor and head at Center for Trade and Investment Law. In this capacity, he advises the Government of India. He is also a founding faculty at Jindal Global Law School and also visits at other law colleges. He's also appeared before the WTO appellate body in cases such as the India Agricultural Products case. Professor James will be talking about his reflections about the MPIA, as well as the other factors which contribute to the current crisis. Finally, then we have our final speaker, Ms. R.V. Anuradha. She is a partner at Clarus Law Associates, where she heads the team on international trade and investment law. She advises the government and the private sector. She'll be she'll be giving the final remarks on the issue, and after this, we'll be moving on to the questions and answers. So Deepak, on to you.
Thank you, Pramiti, for that introduction. Whenever I speak to NUJS students, I say it's great to be back to my alma mater. But today, we actually did a class at NUJS this morning. So it's a second visit to NUJS in the same day. So Rukmini and I are teaching a course on international dispute settlement, optional course for NUJS students. And we had a class already early morning. So some of you may be hearing me for the second time today. So Pramiti has introduced the crisis at the appellate body and at the WTO very well. I'll recap a couple of points that Pramiti raised on how this crisis, especially on the adjudicatory side, came to be. I'll also discuss MPIA, the interim solution which has come up, and the possibility of ad hoc solutions in individual disputes, which may be outside a BIA, but tailored on similar lines. And along with that, I'll also try to speak about what some members may do if disputes end up getting stuck at the stage of appeal without resolution in sight. So first, going to the history of how this crisis came to be. As Pramati mentioned, WTO envisages a two-tier dispute settlement process. The first tier is a panel. The panel is the first instance adjudicator. That's where you present your case and argue all the facts in the law. The panel, at the end of that process, sets out its findings in a panel report. The report is issued to the parties and then circulated to the membership. Once the panel report is circulated to the membership, it is placed before the WTO's dispute settlement body, and the dispute settlement body adopts a panel report through the rule of negative consensus. That means, unless there is consensus amongst all members present at the DSP meeting, unless there is consensus to reject the panel report gets adopted. And it is upon a panel report being adopted that the recommendations and the compliance obligations flowing from that panel report becomes binding. And the timeline for compliance starts from there. The possibility of initiating compliance proceedings to determine whether or not the respondent has complied starts from there. The possibility of adopting retaliatory measures also follows adoption of a panel report. Now, if a party is dissatisfied with a panel report, it has the option of appealing the panel report. And if a panel report is appealed, there's a provision in the DSU which says the report shall not be adopted until that appeal is resolved. So an appeal essentially brings all the procedural steps flowing from the adoption of the panel report on hold until the appeal can be resolved. And the appeal lies to the appellate body of the WTO. That's a standing appellate body, 7 members, and 3 of them sit on any division. A division here is a dispute. There are 3 appellate body members on any division. Now, the DSU foresees that an appeal shall be completed within 90 days. In practice, it has taken longer, in some cases much longer. So it is at the end of the appeal process, the appellate body issues a report, which may uphold the panel report, reverse parts of the panel report, or modify parts of the panel report. And then the appellate body report along with the panel report is adopted through the same negative consensus process. And adoption again leads to the same consequences with respect to obligation to comply, the possibility of compliance review, and the possibility of retaliation. So this was the way for the last 20 years WTO members have resolved their disputes through a 2-stage process. Now, the US has had certain concerns about the appellate body, its function, and the way it has been carrying out its work, some of which have been stated in DSP meetings and in public forums. Some of it may only have been hinted at. So there's a lot of speculation as to where the concerns really are. Anyway, the US for a while, and this is even before the present administration, US had certain concerns about the appellate body. And those concerns, while US had raised some of them at various DSP meetings, any sort of change to the dispute settlement system requires consensus of members. And DSU reform is an agenda item that WTO has been talking about for some time. There's been discussions, there have been special sessions of the DSP, but without really much momentum. So at some point, US started this position that when appellate body members retire, US would not join consensus to launch the process for finding the replacement or would not join the consensus on a particular candidate. So decisions of the DSB, including election of appellate body members, has to be is based on consensus. So all members have to agree for an appellate body member to be appointed. Now, there is an exceptional provision about voting, but that's something that WTO members find very difficult to adopt, and they've been very, very hesitant about voting. So we're still operating within the realm of consensus and consensus seeking. So with each appellate body member retiring and US not agreeing to join a consensus to replace the appellate body member, the appellate body started falling short of 7 members. And on December 10th last year, 2 appellate body members retired, leaving only 1 in place. Actually, I was in the building. I was in the appellate body secretariat on that day because we were filing an appellant submission on that day. So we actually walked into the retirement celebrations for the 2 outgoing appellate body members. And at the time, I was wondering, are we going to do this again? When are we going to file an appellant submission again? Right. So anyway, with that, December 10th, the date arrived, and there's only 1 appellate body member left, which means when you file a notice of appeal, when you get a panel report, you file a notice of appeal, there's no one to hear that appeal. There's also a few appeals which are instituted before December 10th, like the one I mentioned, which are pending, and there's no one to really take future steps, next steps in those disputes, and they're pending. Now, even before December 10th arrived, there was some talk in the trade community about what members were going to do in the absence of a functioning appellate body. There was a sense that at least a few months before December 10th, there's probably a sense among certain members that putting in place anything interim might create a new normal. So a lot of delegates that we spoke to had this, at least at a personal level, they were expressing this view that we don't want to encourage the emergence of a new normal. We want the appellate body back. An appeal is our right, and appellate body is what is envisaged by the DSU, and that's what we want. But after December 10th, I think members have achieved a little bit more of momentum in talking about an interim solution, interim alternatives. So one solution which has come out is the MPIA. Now, before turning to MPIA, I recall the work of some of my colleagues at SITC who had written an article about the possibility of Article 25 arbitration under the DSU as an alternative for an appeal. So Article 25 of the DSU is a little bit of an obscure provision, which as practitioners, we didn't really come across or put to use very much before this crisis began. That provision says, while the DSU provides for various stages of dispute settlement and procedures for each stage, Article 25 says, in lieu of any of those provisions, any of those procedures, members may agree to submit the dispute, at least that stage of the dispute, to arbitration. Now, the paper that I referred to was arguing that this provision could be used in lieu of an appeal, and that would allow for an interim solution where appeals could be disposed of through arbitration while the appellate body is unavailable. Now, that paper also advocated maintaining as closely as possible the scheme of appeals that we had. So while members are free to choose their own procedures for this arbitration, the paper was advocating those procedures should be as closely as possible replicating the appellate procedures envisaged in the DSU. Now, eventually, the European Union and a number of other members have adopted what's called the MPIA, and that is using Article 25 as an interim solution. So that MPIA, the the text is publicly available. Now, it envisages that for disputes in which an interim report has not yet come out, the parties to the MPIA communicate their intention to agree on Article 25 arbitration and resolve the appeal through Article 25 arbitration. Why do we say before the interim report has come out? Now, in WTO proceedings, panels typically provide their interim report to the parties before, well, they have to provide interim reports to the parties before a final report is produced. At that point, the parties actually know what the outcome is, which is why it would be challenging for parties to find agreement on appeal and its procedures once they know the interim report and what the outcome is, in comparison to a time when both parties don't yet know what the outcome is. So the MPIA envisages that the parties will agree on appeal under Article 25 for disputes where an interim report has not yet been has not yet been issued, sorry. And for each dispute, actually, the parties need to conclude such an agreement. MPIA provides the text of suggestions for that kind of an agreement, but it's only a template. And MPIA states an intention to make that agreement and probably goes a little bit beyond and establishes a commitment to explore agreeing on arbitration, but MPIA envisages that each dispute there would be a separate agreement to submit to arbitration. Now, one of the benefits of the appeal system was a standing appellate body, and MPIA tries to replicate that. So MPIA is trying to create a pool of 10 arbitrators, which will be a permanent or a standing pool. And the process for selecting those arbitrators has already started. Some very impressive and very experienced names in the field have been put forward for MPIA arbitrator positions. So we are continuing to watch how this will evolve. There's also a question of who's going to support as the secretariat, the MPIA. So the appellate body was supported by the appellate body secretariat, and the secretariat performs a very important function in providing assistance to the judges in terms of legal research and helping them analyze the issues. And they're very much part of that process, and their contribution ensures institutional knowledge across time and consistency across reports. Now, MPIA has a paragraph which says that it will be supported by a system which is distinct from the WTO Secretariat. But the Director General of the WTO is requested under MPIA to ensure that such a mechanism is available. What exactly that mechanism is and to what extent the DG can or will provide that mechanism and how much of a relationship exists between that mechanism and the WTO is all matters of a lot of discussion right now. In fact, one of the concerns that US has raised is whether MPIA will be financed through WTO's budget, and US has attempted to raise the issue in budget discussions and to make sure that WTO budget does not go to supporting the MPIA. And so again, there are a few points to be resolved there. But at this point, a number of key players have joined the MPIA. There are others who are considering it. Now, outside MPIA, Article 25 still exists outside MPIA, which means that even members who do not join MPIA have the option of agreeing to submit an appeal to arbitration and get a resolution of the appeal through arbitration under Article 25, even on an ad hoc basis without joining MPIA. Now, I'll conclude by observing one more thing, that is, while MPIA is an attempt at providing a solution, some members have also started thinking about what's the stick to induce other members to go for the solution. The EU in particular has suggested that if EU prevails in a dispute and The respondent appeals into the void, that's appeals to an appellate body which is not currently available and does not agree to resolution through Article 25 arbitration. EU may take unilateral retaliatory measures to address the nullification and impairment that EU is facing as a result of continuing violation. Now, this is quite interesting. Before all of this happened, before the appellate body came down to one person, long back there was a conference in London at which there was a discussion on the arrival, the impending doom date of December 10th and what was going to happen. At that point, I'd raised this idea that there's a possibility of countermeasures under public international law. So states can take countermeasures against breaches of international law by other states. And of course, in WTO, within the WTO rules, there is a prohibition on doing that because Article 23 of the DSU says that members shall not engage in unilateral determinations of a dispute or unilateral countermeasures. And I was arguing at that conference that the prohibition may no longer apply under the current circumstances as a matter of law of treaties, because the conditions on which the prohibition rests, the procedures subject to which WTO members can adopt countermeasures, may have become unable to perform. There may be a supervening impossibility of performance, and that may release WTO members from that prohibition under Article 23 of DSU. Anyway, EU has not publicly expressed an opinion on that argument or on why Article 23 of the DSU does not dissuade them. But in stating that they were going for unilateral countermeasures against members in these circumstances, they seem to be indicating that the EU is not bound by the prohibition in Article 23 of the DSU, and they have actually stated in language of countermeasures. So it will be interesting to see if other members challenge the EU and what the EU's response is as a matter of law for that kind of challenges. Anyway, I will conclude with that, and I look forward to hearing from James and Anu.
Professor James, over to you.
Yeah. So thank you. I hope I'm audible.
So your voice is a little faint, I think.
Okay. Can you hear?
Slightly. Yeah, now it's fine.
Okay. All right. So I think thank you for this opportunity, Paramiti. It is a pleasure to be with Deepak and Anuradha for a very important discussion. So Deepak has very clearly outlined the issues, the genesis of the problem at the WTO appellate body. What is MPA all about? And he spoke about some of the current thinking among the major proponents of the MPA, like the European Union. So while coming back to the problem, I think most of the trading community, especially the key trading players, were aware of December 10 for a fairly long time. So we can say that nothing is actually surprising. That the appellate body would be reduced to one, that countries would file appeals to the void, that even Article 25 interim arbitration appeal mechanism can be an alternative. So some of these things are actually not new at all. But at the same time, I'm pretty heartened by the fact that 17 countries, including the European Union as one, have shown their interest in finding a kind of an alternative mechanism, at least for the time being. I think if you look at the concern of the European Union or other members, the proponents of the MPAA, the concern seems to be that the present crisis is actually limited to the appellate body. But if this crisis is allowed to continue for a long time, it can completely destabilize the dispute settlement mechanism. And therefore, it can actually render the entire set of WTO agreements, the entire covered agreements, to maybe a redundant piece of agreements. But now look at what is actually happening. So there was a congressional hearing in the United States very recently. The US Ambassador Robert Lighthizer clearly said that if the appellate body is not going to come back, it is just fine. But one of the concerns appears to be that even the United States may not worry if the panel process or if the dispute settlement process itself is going to be completely turned dysfunctional. And this feeling actually comes out of a feeling that the multilateral trading system is not working in favor or to the expectation of the original proponents of it. So there is a deep, you can say, a deep lack of trust in the multilateral trading system, maybe attributable to the lack of major or significant progress in concluding agreements. So Paramedi in the opening remarks mentioned that the Doha round is almost dead and countries spend nearly 20 years negotiating it. So when we think about the crisis at the WTO, we should not be actually looking at the crisis of the appellate body. The entire multilateral trading system is going through a major crisis. And the most important crisis, in my opinion, is not the AB crisis, but the inability of the WTO as such to conclude agreements. And here we have some kind of a light at the end of the tunnel. My feeling is that the WTO may at least, the WTO members will at least try to have one agreement, that is the agreement on fishery subsidies by the end of the year. And if it happens, perhaps the WTO has done something, has accomplished something in terms of negotiation. So while we think about the current situation, we all know that there is a general amount of feeling within the industrialized countries, maybe the Western powers, that the multilateral trading system is not actually working in their favor. And that is why I think the appellate body is only, it is only a symbol. So over a period of time, countries have been exploring various regional trade agreements. The TPP is one such agreement. India and many other countries were involved in the RCEP. So if you look at all these developments, we can very safely say that it is very difficult to conclude any major agreement with any kind of substantial provision. So there could be significant amount of backlash against these kind of agreements, and countries will react. So that is why we are not actually in the mood for opening up. We are not in the mood for trade liberalization at the moment. So looking at that way, my feeling is that the MPA is definitely a good sign. It's a very good, at least a very good interim solution initiated by the European Union, Canada, and other countries. But at the same time, there are some major omissions. One of the most important omissions is the United States. India has also taken the decision, to the best of my knowledge, and Japan is not part of the MPAA. Even Argentina is not actually part of the MPAA. But at the same time, you can argue that there is a certain amount of a critical mass among the WTO members, among the leading parties in the dispute settlement system, to have an interim mechanism. So what I'm going to do in the next part of my talk is to analyze whether it is really or indeed a good thing. When we look at the history of the WTO or maybe even the GATT, if we allow some of these ad hoc or interim arrangements to continue for a long time, it actually happened that these interim arrangements became the norm. So the MPA is only an interim arrangement. So long as the appellate body members are recruited, the MPA can actually remain in force. Once the appellate body becomes completely functional, then the MPA will go out of the window. But I do not know whether this will happen very soon. So we are actually staring at a future where the interim mechanism can become the new normal thing. And if it happens, then of course we have to look at the situation. So the United States is the most important trading member at the moment in terms of disputes. Both the European Union, China, and Japan, and even India for that matter, have got a number of disputes against the United States. So if the US is completely outside the system, the one critical concern is, can they actually free ride? Can they be completely free of any kind of trade commitments, while at the same time they can file disputes through some of their surrogate countries and make sure that the trade obligations of other countries are enforced? So that is a real challenge. So my own feeling is that any kind of a mechanism, even an interim mechanism, if it cannot actually include the United States, will have very limited value. The second point is, so the MPA is considered to be a kind of an interim mechanism. And why the MPA is actually thought about? Because there is a feeling that the losing party will appeal into the void. My own feeling is that this is only a second best or maybe a third best solution. We know that if you look at the history of all WTO disputes, even in cases where the appellate body has overturned some of the findings of the panel, they haven't completely overturned all the findings. So the countries that lost the disputes actually lost the dispute even at the appellate body. So in my opinion, the best solution is to take a decision that no country will actually appeal against each other. And if countries can have that kind of an arrangement, that kind of a tacit agreement among themselves, then the MPA solution can be basically averted. And think about some of the systemic issues with the MPA. So the MPA, although it is called an interim arbitration appeal mechanism, it is actually a panel process. And to an extent, it does a significant amount of damage to the integrity of the current panel process. Because when the final panel report is available to the parties, 10 days prior to the release of the report, the parties will have to notify for the appeal mechanism. And we do not know what will actually happen to the panel report. And secondly, and most importantly, the arbitral awards are not adopted by the dispute settlement body. So if the arbitral awards are not adopted by the dispute settlement body, they may not have a legal force. So that is a serious concern. But on the other hand, if countries take a decision not to appeal the rulings of the panel, the advantage is that the panel rulings will be adopted. They will have certain kind of legal value. But the interim arbitral mechanism is too much of an ad hoc mechanism. And the procedure for carrying out the interim arbitral mechanism is very much complicated and ad hoc at the moment. So there are serious concerns about it. And I feel that countries, including India, are just waiting and watching. So there is also a feeling that, countries like India should come to the forefront. This is the time for us to show our leadership. My own feeling is that we have to wait because not because India has got a number of disputes against it at the WTO. If you look at the recent panel requests, most of the cases are actually against India. But there is one thing. The real issue is that, if India joins this particular process, will the initiative or will the restoration work to bring back the appellate body be completely defeated? Or will WTO members actually lose interest in that? In that situation, there can be only one winner, the party that has completely blocked the appointment of members to the appellate body, which is the United States. And in that situation, my feeling is that as a country, India will have to pursue all good faith efforts and attempts to make sure that the appellate body is restored at the earliest. But at the same time, I'm not saying that we shouldn't reject the MPA mechanism. The MPA mechanism may have certain kind of an attraction. If this kind of an impasse is going to continue for a long period of time, then we may have to take a decision. But at the moment, I do not think that the time is actually right for India, or maybe even for Japan or other countries which are not part of the current proposal, to embrace the system. The second important point is actually about the value of all the panel reports after the MPA comes into force. So we know that at the moment, although there is no principle of stare decisis in international law, there is at least some kind of a legitimate expectation that the panels will follow the appellate body ruling, or in certain cases, the subsequent panel may actually adopt some of the principles of the earlier panel. But once the MPA mechanism comes into effect, the original panel report will not have any value. I don't know whether that panel report will even be released. The second issue is the arbitral reports will not have any kind of particular value. There won't be any jurisprudence. So that is actually, I think, for all students of international law or maybe students of WTO law, to live in a world without having any kind of authoritative judicial pronouncement on an issue is a disappointing outcome. So I feel that there are so many unanswered questions at the moment. Perhaps it is good for countries like India to wait. And even if you look at the appeal arbitration mechanism, there is a review after 1 year. So I don't think that we will be missing the bus, for the simple reason that if India is not actually part of the mechanism, it may not have that kind of a value. If the United States is not part of the appeal mechanism, it may not have, significant value. So it is in the interest of other proponents of MPA to bring in these countries. But let me tell you, these are all interim solutions. The real solution is actually bringing the appellate body back to work. And therefore, my feeling is all these countries should try that work on a priority basis. MPA can be a temporary interim solution, but our effort should be concentrated in bringing the appellate body back to life. So I will stop here, and maybe if there's an opportunity for interaction, I will use that time. Thank you.
Thank you, sir. Anuradha, ma'am, over to you. I can't hear you. I think your mic is still muted.
Sorry, can you hear me now?
Yeah.
Okay. Thank you. It's actually, I think, coming after Deepak and James has made my job a little easier, and I'll try and be brief so as to give more time for discussions. I already see a few things, a few points on the live comments, which we can address. But very broadly, starting on the MPIA, the point that I wanted to simply supplement what Deepak has already said is the fact that I view the MPIA as a pilot project to try and preserve the WTO enforcement mechanism. As students of trade law, most of you would have understood and learned that the uniqueness of the WTO system is the fact, not only of the fact that there is a two-tier mechanism for dispute settlement, but how Deepak briefly explained in the beginning, the entire mechanism drives a process which leads to enforceable rules. Now, in the absence of that, what will it mean to the system? And what's the risk to the system? It really is a messaging that if I lose a dispute, I can simply raise an appeal, which will effectively mean that the panel report doesn't get adopted, which means essentially it's a position of not having to adhere to a ruling, which then means are other countries going to remain quiet? Perhaps, most probably not. So it's actually going to lead to greater unilateralism. And what will that mean? It will essentially mean that the entire structure of WTO and multilateral rules and agreements then, to a certain extent, essentially come to naught. Deepak raised the issue of EU suggesting that countries which were to do that are misusing the system, and therefore they should be entitled to implement countermeasures, which is essentially, as he very nicely explained, will go against the principle of Article 23 of the DSU. But again, as he tried to argue that perhaps it's a very interesting argument that he's making, whereby where he's saying that the law of treaties essentially envisages that if a supervening event is going to make resorting to a particular provision impossible, then can it not be argued that a unilateral measure is something that is legitimate pursuant to a panel ruling which has been issued? Just a point on that, I think, one, we will be then treading into extremely slippery slope if we were to go down that route. Secondly, the EU, when it has made its proposal in December, it actually made a proposal for amending one of its regulations relating to enforcement of international trade rules, where it actually says, Deepak, that they are finding legitimacy for this in the draft principles of state responsibility. And what they have tried to argue is the fact that countermeasures is something which is embodied in the draft articles on responsibility of state for internationally wrongful acts, and that this essentially means that a party taking countermeasures is not relieved from fulfilling its obligations under the applicable dispute settlement procedure. But when the dispute settlement procedure itself is something which is on shaky ground, they've tried to actually find legitimacy under this. Now, the problem I find here is that, as you may or may not agree, that I would argue that draft articles on responsibility of states is not really part of customary international law. It hasn't been codified and recognized as part of customary international law. So EU seeking legitimacy under this in itself is something which might unleash another round of unilateralism. Now, what happens if you do not go down that route? Because EU is saying that I'm trying to be a good person, I'm trying to follow the MPI, I'm trying to find a solution to the crisis. And if a country seeks to misuse the system by not relying on MPI, I have no other option. Now, let us take the example of another solution, which I think what James was alluding to, which is that what if countries decide not to appeal? So basically, if I understand you correctly, James, it's a situation where two countries which are parties to a dispute decide that, okay, there is a panel ruling and we are not going to take it to appeal. Let's sit across, discuss and implement it. Now, there are two questions here. Are we then saying that let us do away with the appellate body? Then will the panel ruling effectively get adopted because the parties agree not to appeal, which is the logical consequence under WTO? Or would it mean, what US has been alluding to, and the way I read US, what they've been saying is that this needs to be more member-driven and member-controlled. So if US were a party to a dispute, and one would imagine that they probably have a stronger leverage, a stronger negotiating stand, it would essentially mean that they can sit and, in a sense, whether they are a losing party or a winning party, negotiate the shape of the implementation. They've also been alluding to sequencing agreements which they have successfully implemented in the past as examples of how members can get together and agree on how to resolve any kind of conflicts within the WTO implementation system. And this is a way in which they can actually ensure that there is a seamless implementation of WTO rulings. The difficulty that I find here is that this takes us again back to the pre-WTO era of a member trying to have greater control over the system, whereby there will be no possibility of a second-tier appeal process. And it's essentially up to the negotiating power and power dynamics of countries concerned in how they want to take this forward. So, all in all, I think to bring it, to kind of summarize the entire issue, I think that MPI is a critical experiment, and the success of these, I would actually say the 16 plus the 27 EU members, which is a significant part of the membership, as James noted, their implementation of MPI, as we speak, as far as I have seen, at least 4 or 5 countries have actually resorted to the MPI. They've actually filed their agreement that, should Canada, Brazil, Costa Rica, Mexico, in 3 disputes at least, have gone and, made their intention clear that they would like to resort to the MPIA post the panel process. So, which is an indication of good faith, I would say. And then it's for the other members to, as James is suggesting, the wait and watch approach to try and see whether that would actually, if this makes sense to continue. Now, whether this will replace the need for an appellate body, the point that James is trying to make is if interim ad hoc arrangements can become a future possibility as a permanent arrangement. Now, honestly, James, obviously that will happen only if all the countries actually agree to this, or as you're suggesting, if they are able to find the compromise for the appellate body, nothing like it. Having said that, from October 2018, that is the first time when US blocked the appointment to the appellate body, members have been trying to thrash out what are the solutions, how to address US concerns. But honestly, the way I see the current US administration dealing with this whole issue is that they just do not want the appellate body. So are we faced with a situation of no appellate body versus a 2-tier system, which is, as of now, the appeal arbitration process under MPIA? I would actually prefer the latter as a better solution. Or, as you were suggesting, our countries somehow going to be able to break the deadlock, which they honestly were not able to do so for a good 18 months at least. I think that's, again, still remains to be seen. But just very quickly, coming back to the issue of the overall, I know we've kind of, this has become more of a discussion on MPIA and not about the other crisis of the WTO and the NUJS team. Perhaps we need another session to discuss all of that. But just to highlight the point that this whole issue of, I think one of either James or I think Deepak had mentioned, or maybe Pramiti had mentioned in her opening about rising unilateralism. And this is something which is not confined to a US or to specific countries. It's actually a worldwide phenomenon. And I would urge all of you to read UNCTAD's 2018 Trade and Development Report. It's got a fascinating name. It's, I think, something about power politics and the free trade delusion. And what they actually try and argue is that unilateralism is something which has absolutely no developing country divide. Practically all countries across the world have been implementing measures that just reek of unilateral protectionist measures since 2008, which is the point of the financial crisis. And this again raises very critical questions in terms of what have trade agreements really served? What kind of purposes and objectives have they achieved? James alluded to the point that perhaps the developed countries are no longer comfortable with a growing opposition among the developing countries. It is true we are no longer in the age of the benevolent hegemons, the US and the EU pretty much dictating where trade rules are going to go, and it is a far more, in a sense, a democratic kind of a situation, but also a situation of complete chaos. And in that kind of a situation, James, for a country like India to stay and wait and watch, I'm really not convinced is the right approach. We've been right from a founding member of the WTO in 1947, of the GATT in 1947, we've played an important role in the multilateral sphere. So now to take a back seat and wait and watch perhaps is really not a sensible approach. Neither is our own indulgence in increasing protectionist measures. So with that, I think I would actually turn on to the moderator for chairing the discussion session. I see quite a few questions, but yeah, your thoughts on how we should actually steer this. Pramiti, you're muted now.
Sorry, thank you. Yeah, so I'll jump right into the questions. Saish Kamath has asked, and this is a question for Deepak. Did you mention voting as another option instead of consensus, and that countries were hesitant to move to that? Could you please elaborate a little bit on that?
Deepak, you have to unmute yourself.
Sorry, I've been using different video systems and finding the unmute button sometimes tricky. So the DSU has a provision which says that all the DSU shall be taken, the DSB shall be taken by consensus. But when you look at the Marrakesh Agreement, which establishes the WTO, paragraph 1 says the WTO shall continue the practice of decision-making by consensus under GATT 1947, except as otherwise provided, where a decision cannot be arrived at by consensus, the matter at issue shall be decided by voting. And the Marrakesh Agreement actually would allow you to take a number of, including an amendment to the DSU. So at some point, if members decided that they had enough vote, there's a number of solutions that they could adopt to powers conferred under the Marrakesh Agreement, which could include amendment to the DSU or authoritative interpretation of the DSU. And in some of the early discussions leading up to December 10, there were people who were talking about the option of voting, but the institution has traditionally prided itself in being one driven by consensus, and voting seems to be a no-go for, at least for most of the missions working and diplomatic missions working in this area. Any voting-based solution seems like a complete no-go. And there are good reasons for that, and I think part of it is the fear that a very big member, which accounts for a very big part of the trade, may leave, or maybe further anti. So yeah, the point is, as the legal voting and it may be a series of different votes that may need to be taken to solve the problem. But while the legal par itself, it's not something that missions are or diplomats working in this area are even willing to seriously talk about. I've only heard academics and those discussing about this.
Can I just come in there?
Sorry, Pramiti, were you saying something? I can hear someone.
No, the connection is really poor. I'm not able to hear very well.
There is a lot of echo. I think the echo is on user and mic. I just wanted to, can you hear me?
Yeah.
I just wanted to reflect on what Deepak said. Deepak, what you say is interesting, but actually the Marrakesh Agreement under Article 10, while it envisages voting for the amendment of the Annex 1 agreement, so GATT, GATS, all of that, you can actually do a voting. And I agree with you, countries have generally been hesitant to do that. But for DSU, Annex 2 agreement, the Article 10 of the Marrakesh Agreement says that any amendment to the DSU can happen only by consensus. But except that that consensus decision can be through a ministerial decision. So what you are suggesting can work if the Marrakesh Agreement itself is amended first and then the DSU. And that becomes a trickier aspect because we're pretty much then changing the fundamentals of the
Yeah, that's right. I know that's an additional step. So that's why there's a series of votes that's right. I know that's not a realistic option. That's an additional step. So that's why there's a series of votes that they would need to take. That's not a realistic option. Pramiti, I'm hearing myself back. I think someone has their unmuted. I'm hearing myself back. I think someone has their.
I'm not very sure what the issue is. I think because I think we're all muted apart from the speakers. So I'm not very sure what the issue is. I think because I think we're all muted apart from the speakers. Is it getting a little better? James, if I could ask you to just mute yourself right for a minute. We're not sure where the issue is. Is it getting a little better?
Yeah, I can hear you, Pramiti.
James, if I could ask you to just mute your...
Mute. Oh.
Yeah, I think it's better now. Okay. So if on that question of voting, if there are no further comments, I think I could move to the next question, if that's fine. So Arnav has asked that whether the MPIA could function similar to the ISDS system, because arbitrators would have a wider scope of interpretation as compared to the present system of the WTO appellate body, where under Article 3.2 of the DSU, they have to strive to maintain a harmonious interpretation.
Yeah, maybe I can just reflect on that a little bit. Under the danger with, okay, let me actually first tell you what EU's the statement, the communication that the current proposal on MPIA talks about. And they do refer to the fact that, Deepak, correct me if I'm wrong, but I think there is a para which talks about the importance of maintaining certainty. Which is again very similar to the appellate body practice. In fact, US has criticized that to say that this is actually preserving the appellate system in it's like an old wine in a new bottle sort of a scenario. But having said that, the danger with an ISDS sort of ad hocism is probably going to be more a fragmented jurisprudence. Whereas I think there is a lot of value that of some kind of a continuity and predictability through consistent set of interpretations. And in fact, the MPI envisages that the panel of arbitrators that Deepak was referring to, who are constituted, will interact with each other and share their views, so that there is not much of dissonance. So that's one of the aspects, that's the way they're envisaging it right now, and I think there's a lot of value in that. But because an ISD is sort of a ad hocism, may be more riskier.
If I can just add to that, a couple of points. So first of all, one of the basic objectives of the DSU is stated to be predictability and security of the multilateral trading system. And as an adjudicator who derives power from the DSU, of course, the arbitration tribunal will have to be sensitive to that requirement of predictability and security. Now, separately from that, if you were to ask whether there is a risk of MPIA having to incoherent decisions as between different arbitrations, similar to what has happened in ISDS, I think there is a risk, but it's not as bad as ISDS. So, of course, the appellate body was a unifying force. They could review panel reports and ensure that the appellate body's views, which are expressed in previous disputes, prevailed, and there was uniformity in adjudication throughout time. So they essentially made sure everything was consistent. If you're talking about the appellate body not existing and MPIA replacing it for a period of time, yes, we lose that institutional supervision of the appellate body. We hope that MPIA arbitrators will play that role, but there's an institutional history and institutional memory that's lost with the appellate body, at least for a period of time. But why do I say it won't be as bad as BITs or ISDS arbitration? When you think of inconsistencies in ISDS, you're thinking of jurisprudence around things like the definition of an investor. If you ask an arbitral tribunal what's an investor, you'll get two very different schools of thought. If you ask whether an MFN clause applies to dispute settlement, you get completely different schools of thought. Now, part of the reason why that happens in the world of investment is because of the way BITs are drafted. A lot of them are fairly bare bones and make certain statements without a lot of elaboration. For example, when you say investors shall be given fair and equitable treatment, what does that mean? And you turn to judicial interpretation to find meaning for that kind of wording, which leaves a lot of room for arbitrators to come to their own views on what those provisions mean. And they have to, sometimes they disagree with each other. But WTO agreements are written in much more detail. There is still room for interpretation. It exists in any treaty. But the amount of detail in the WTO agreements will sort of take away from the room for that kind of inconsistency or that level of inconsistency in comparison to ISDS.
Can I make one comment?
Sure, sir.
This is something very interesting. So let me actually talk about an issue like zeroing in dumping margin calculation. So now the United States is not party to it. The country which has got the maximum kind of opposition to a prohibition on zeroing. So the European Union, China, and other countries which are part of the MPAA can come up with a certain kind of arbitral awards that completely prohibits all categories of zeroing, maybe even zeroing in targeted dumping for that matter. So now think about a situation where there is another dispute between India and the United States, which are not actually parties to the MPAA, but a normal WTO dispute is happening between them. To what extent the report of the MPAA arbitral award can be used in the matter between India and the United States? So my own feeling is that some of these reports are of absolutely no value. And secondly, I think the danger is that, this is one potential danger. At least in the current system, the panel reports, if they are adopted, have got certain kind of a sanctity. And that is also referred to in the Marrakesh Agreement. So these are actually practices which can be used or should be followed by subsequent panels. But in a situation where some countries are actually part of the MPA, some countries are outside it, I don't think that there will be some single authoritative value of the MPA arbitral award. It will be an arbitral award completely confining or binding the relationship between the two parties involved in the dispute. So there are certain and huge amount of systemic issues involved in this matter. And I also saw a comment actually with respect to the presidential value of the MPA award. So if I can, I don't remember the name of the student who asked that question, but from what I understand, this MPA award may not have any kind of value or legitimacy. There is absolutely no need to provide cogent or compelling reason as to why a WTO panel should ignore the reasoning of a arbitral body. So to that extent, my feeling is that the kind of legal system that we have built up over a period of years can only be weakened with the introduction of the MPAA. But the suggestion which I was making is that if countries can, so even in the MPA, countries are voluntarily taking a decision to be bound by a particular arbitral process. If they can actually have that kind of a unanimity decision not to appeal and make a decision that the panel will be completely binding the relationship between the two parties in the dispute, my feeling is that it can preserve the integrity of the dispute settlement system and the primacy of the panel process to an extent.
If I can just respond to something James said.
Sure.
So the question of precedent is always a very interesting one. And that's also part of what is at the center of this whole debate with the US and the rest of the world in this system. So US has a certain view of how precedent should operate, and the appellate body and the WTO dispute settlement process have evolved in a different direction, and that's also part of this whole debate. But let me just take a step back and think of another very famous arbitral award. So 1932, an arbitrator called Max Huber delivered an award in a case called Island of Palmas. Island of Palmas case was about a sovereignty dispute. It was about whether US or Netherlands had sovereignty over an island lying close to Philippines. And Max Huber was appointed as arbitrator because US and Netherlands agreed that he would be their arbitrator. And he rendered an award which lays down as the test of sovereignty a prolonged and peaceful exercise of sovereignty. So he says if you've exercised sovereignty for a long period of time, and if you have not encountered protest by other states, that solidifies your title of sovereignty over that piece of land. He also came up with the principle of intertemporal law. So law prevailing at a given point in time should be applied to determine factual circumstances prevailing at that time. Now, Max Huber was sitting as an arbitrator appointed by just 2 states. But today, if you look at any dispute about territory before the International Court of Justice, before law of the sea tribunals, if they're talking about territory, you find a citation to Max Huber's award in Island of Palmas. That's not because Palmas award has any binding force on an international law. It's not because all of the states which are parties to future litigation somehow consented to be bound by Max Huber's award. It's simply that a lot of people, a lot of future adjudicators think that Huber's award is right. Now, there's also a separate opinion in Barcelona Traction, I think, which says the problem with Huber's award is not that it's incorrect, the problem is that it's correctly wrong or clearly wrong. So there have been adjudicators who disagree with it as well. But my point is, we don't have a formal system of precedent, and MPIA awards can be referred to in the same way people refer to Huber's award or an ICJ case raised before WTO panels, or even like one WTO panel's decision being raised before another WTO panel. Now, of course, WTO panels can be more careful in examining those citations, those reports, pursuant to the fact that they've not been adopted. But I don't think that they should be dismissed entirely.
If there are no further comments on that question, we could just move to like one final
one more
question.
point which I want to Parmiti just wanted to mention one more point, I think. See, so we have to actually examine why the MPAs is being spoken about. It basically comes into this situation only because the United States was extremely unhappy with the kind of functioning of the appellate body, especially with respect to areas like gap filling. So if the MPA is going to be a sensible organ, my own feeling is that they will have to be extremely careful in the way in which they write their opinions. They should be extremely careful in order to trench upon many areas. So that way, my feeling is that from a conservative point of view, they'll be very careful not to ruffle the feathers. I think they will be giving a large number of compromise awards. And secondly, the one point, which is actually one question concerning India as well, I want to mention this point. So countries including India may have a number of disputes against it at the moment. So if you look at the recent WTO cases, India is the leading defendant or the respondent. That can be a factor in terms of India's ultimate decision to join the MPAA. But I mean, as Anuradha mentioned, I don't think that we will actually surrender our leadership role in the WTO, because there are many other countries like Japan. Japan is a very powerful player in the system. Japan hasn't joined it. Argentina is a very important player in the dispute settlement system. They haven't joined it. And given the fact that we are the leading or the largest respondent, I think it actually, it is in our favor, because the other countries would like India to be part of the MPA system. And given the fact that, now there is a new panel against India's ITA duties, there is a panel with respect to the sugar matter. I'm sure other countries would like India to be part of the system later on as well. So in India's case, my feeling, for the time being at least, it's a very new mechanism full of complications. Let us see how it actually functions. If it is functioning reasonably well, I think we should calibrate. We should actually take a decision at a later point in time. But at the same time, nobody should, I think, reduce our efforts in restoring the appellate body, which has been, I think, the single most important or the central piece of success in the WTO. So if we lose that effort, then of course we are going back to the GATT days.
Do we just have time for one final question, I think? That's okay with all of you? Also, James, I'm sorry, could you please mute your mic for a minute?
Sure.
Thank you. So I saw that there were a couple of questions regarding the optics of this, whether this is considered to be like a failure of the WTO. And I personally had a question about how that ties in with the broader debate about multilateralism versus fragmentation. Because I'd read that it's quite obvious that when the costs would outweigh the benefits for a particularly powerful country, they would withdraw from the international legal system. And one of the ways in which they would do this is through weakening the judicial system and sort of lowering the enforceability of the judicial awards. So now, in light of the fact that the US is so reluctant for all of the reasons that we've discussed, how possible is it for other countries, both powerful and smaller countries, to really band together to resist this move away from the multilateral trading system?
Well, if I can take a shot at that, really, there are no easy answers. I think, one can only hope that this is a temporary blip, even with regard to US's position, and that after the elections in November, whichever is the administration that comes to the fore, there will be a concrete way forward. Going by the signs of the current US administration pulling out of other multilateral institutions as well, the WHO, then pulling funding for UN agencies, the WTO itself, and the fact that this is actually, the world is now, in a sense, we're seeing more of China-related funding to keep these institutions alive. And so it's kind of a very strange configuration, because one of the other aspects to kind of throw it into the mix is that there is this growing trilateralism between the US, EU, and Japan, which have been, these three countries have been meeting consistently along the sidelines of the WTO and otherwise to try and address certain critical issues, and especially very China-centric concerns. So it started with addressing, overcapacity on steel and other products, and how, what sort of new agreements are required to address that. It moved on to I think very recently, a couple of months back, there was another trilateral meeting between the three addressing subsidies from China, which really are a problem not just for those three countries, but for practically all countries worldwide, and India also to a large extent. So at one level, there appears to be a recognition, even among among all the at least the three of the most powerful members globally, in terms of where should be the new shape and form of trade rules and international rules. On the other hand, there is a existential threat to existing systems. So it's absolutely not clear, whether they want to. There is a vision to tear this up and recreate something, or whether this is, as I was mentioning, and I just fervently hope that it's a temporary blip, and that it's more a question of evolution of something for which countries need to come together to try and forge that, whichever way it's going to go forward. So yes, it's if the question is whether WTO as an organization can benefit from the optics that it may have. It's not just the optics, it's the optics and the extremely substantive role that the institution itself can provide. And if not the WTO, then I think, as I think James mentioned, that years together countries can keep negotiating, and it just takes a long time for something concrete to work out. Even the Uruguay round, students of international trade history would know, it took a very long time to actually crystallize. So to see whether something can replace it, I'm not very optimistic. Can it be resurrected? That's the hope.
Pramidi, can I say something?
Yes, absolutely.
So I completely agree with Anuradha that WTO is actually, it is irreplaceable. And I also agree with Deepak that WTO agreements, WTO agreements are very comprehensive agreement. Sometimes people may argue that the provisions are outdated and it is not actually a 21st century agreement. But at the same time, if you look at the field of international trade, most of the governmental measures can definitely be captured by the national treatment provisions or the ban on quantitative restrictions. So the WTO agreement, even in the current situation, is actually potent enough to deal with the kind of various protective measures. And again, my own feeling is that, if you look at some of the issues, like agriculture issues, I don't think that any bilateral agreement or a free trade agreement has actually captured the same kind of commitments as we have in the agreement on agriculture, or even for that matter, the anti-dumping agreement, the SEM agreement for that matter. So, in terms of real, I think, breadth and reach, the WTO agreements are high caliber, high class agreements, and countries will be compelled to file disputes. So I can only expect, many more disputes going to the panel stage. And so long as more disputes are coming to the panel stage, irrespective of whether we have an appellate body or not, I think people are reposing their faith in the system. Maybe, as Anuradha rightly said, this can only be a blip. Maybe, after November 2020, we will actually find a new resurgence for finding a lasting solution to the appellate body crisis. Maybe all the WTO agreements will get a reset. There could be new negotiation, because if you look at the Uruguay round, given my own expertise with trade remedy law, there was a number of very good proposals actually. Some of the proposals are now coming back. Now the US has actually made some proposal on market orientation within the WTO agreements, basically, dealing with China and other countries. So there are certain areas where the WTO agreements need some kind of an updation, and I feel that maybe in 2021 we will have a bright future. Thank you.
That's very optimistic to hear. Deepak, if you had any comments on that? So could you please mute your mic?
Right, sure.
Yeah, I'll also end by agreeing on that note of optimism that we hope that 2021 is going to be a better time. And a silver lining in all of this is that members, including the US, continue to institute disputes at the WTO. So the dispute settlement system, members still seem quite heavily invested in it. And I hope that commitment will lead them to resolve this impasse. And I need to reiterate something that James said earlier. Whether you're talking about MPIA or any other interim arrangement, it's a second best option. The best option that we could hope for is a return of the appellate body. So given the optimism that we're ending this discussion on, my optimistic hope is that we will see the return of the appellate body. Thank you.
I think that's quite a good note to end this panel session on, because I think we're also running out of time now. So unless there are any final remarks, I think we can end the session here.
Thank you, Pramidi.
Thank you,
sir.
Pramidi.
Thank you, everybody.
Right. Thank you, everyone. Thank you, Anuradha and Deepak as well.
Yeah,
Yeah,
James and
just
Anu, nice to
Right.
thanks
yeah,
for bringing
nice to do this with you guys.
perhaps we need to also second
Sorry, I think the voice is echoing a lot again.
Sure.
Yeah, I think it's better.
Yeah, I think
Okay.
James sir just left.
Oh, okay. Yeah, but anyway, thank you for organizing this, and yeah, all the very best to you all, and maybe we can also think of another session to deal with other issues on trade law.
Absolutely. Thank you.
Thank you.
Thank you, ma'am. Ma'am, there's a concluding remark. There's a concluding remark. No. On behalf of the SITC and the SJ, we would like to thank Dr. Nedumpara, Ms. Anuradha, and Mr. Raju for a wonderful session. Thank you, Pramiti, for moderating the session. We would also like to thank the viewers for their questions. I'm sure that this session has made our viewers aware of the problems that plague the WTO at the same time, keeping them stimulated during this trying time. Thank you.
Thank you.
Thanks, everyone.